Hello, everyone. I'm Christine Zako, Senior Counsel in Husch Blackwell's Healthcare, Life Sciences, and Education team. Thank you for joining our program today. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. All materials for this presentation are available in the Program Materials folder. This program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. Presenting with me today is Mackenzie Conway and Ellen Armentrout. An education attorney, Mackenzie is a former teacher who understands the demands education clients face. Prior to joining the firm, Mackenzie taught students of diverse abilities and backgrounds at a public charter school in Kansas City. She also served as a Teach for America Corps member. At a granular level, Mackenzie knows what issues educators face on a day-to-day level. Known for being an approachable and effective communicator and listener, Mackenzie leverages her education background and legal skills to navigate educators through legal strategy and solutions. Ellen is committed to assisting higher education clients with all their compliance needs. Prior to joining Husch Blackwell, Ellen worked for 15 years as an attorney in the General Counsel's office at Michigan State University. During much of her tenure, she worked closely with academic and administrative units throughout the university on complex compliance issues frequently involving matters of great sensitivity. Ellen's current practice also consists of working with her clients on compliance issues, including the Clery Act, Title IX, and VAWA. She advises on public records requests and policy development, as well as all types of governance documents. That is it for the housekeeping items. Let's get started with our program. Our session today is going to provide a high-level overview of federal non-discrimination laws. Please keep in mind that today's webinar is intended to be an introduction to these laws, so we are not going to dive too deeply into their complexities or nuances. Rather, we want to leave our session with a basic understanding of each law, how it might apply to your institution, and the law's basic compliance obligations. Please keep in mind that our team provides more advanced sessions about many of these topics in other webinars throughout the year, and we encourage you to keep your eye out for these announcements. We're going to start today with an overview of Title VII and Title VI, and I will turn it over to Mackenzie for that discussion. Please bear with us. It appears that we are having some technical difficulties, and we will sort those out and begin the program.
Can you hear me now? Yes. So sorry about that for the technical difficulties, folks. You'd think that this far into webinars we would be pros at this by now. So I appreciate everyone sticking with us. You didn't miss too much. I apologize. As you can see here, Title VI on the screen, the language from Title VI of the Civil Rights Act of 1964. It prohibits discrimination based on race, color, and national origin. So under Title VI, no person in the United States shall be excluded from participation in, denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. What does this mean in practice? Title VI prohibits entities that receive federal funding from engaging in race discrimination. And this applies to any program or activity receiving federal financial assistance and is enforced by the Department of Education's Office for Civil Rights. For institutions, there are requirements under Title VI for what the institutions need to do. So for one, institutions need to prominently display posters in reasonable numbers and places that note that the agencies are subject to Title VI, that also summarizes their requirements, addresses the availability of Title VI information, and also explains procedures for filing complaints. It looks like my speaker is out again. Is that true for anyone else?
I can hear you, Mackenzie.
Thank you. Okay, I'll keep going until I see anyone else that can't hear anything. Great, thank you. And one thing to highlight especially is explaining the procedures for filing complaints. Institutions need to make sure that they provide this information so that individuals are aware of their rights and options if they do feel that they're being discriminated against based on race, color, or national origin. So we have our first scenario and poll question I will get us started with. Institution has a program, the XYZ program, which awards scholarships to students. The XYZ program is only open to African American students. So you can answer this poll question right on your screen. And the question is this program permissible under Title VI? I'll give you a couple of seconds. I will close the poll in about 5 seconds. We always like to include an I don't know because, you know, that's a completely fair option and we don't want to lock you into a choice that you're not sure about. Okay. Again, appreciate the I don't know. It looks like the crowd was split between pretty much two options. So no, because it is not open to students of all race, or it depends on the qualifications for the program. And the majority has it that no, this would not be permissible because it is not open to students of all race. There have been recent OCR resolution agreements with institutions who have had race-based scholarship programs only open to students of a certain race. And with those, the institutions have entered into agreements that they'll change their qualifications for these programs because it is not in alignment with Title VI, even though race is a protected status. And this is even more so with the affirmative action case at the Supreme Court level. So thank you all for that participation. And we will move on to Title VII. Again, Title VII of the Civil Rights Act of 1964. It's unlawful employment practice for an employer to fail or refuse to hire or discharge any individual or otherwise discriminate against any individual with respect to his compensation terms, conditions, or privileges of employment because of the individual's race, color, religion, sex, or national origin. So Title VII applies to employees, prohibits discrimination in employment, both private and public, on the basis of race, color, religion, national origin, and sex. So here we have a little bit of overlap with Title VI and with Title IX. So we won't spend too much time going over Title VII because, as Christine mentioned, we have a lot of statutes to get through. But one of the requirements of Title VII is that notices must be publicly posted in prominent and accessible places where notices to employees, applicants, and members are customarily maintained. So again, employees must be notified of their rights and options under Title VII. And to close us out on Title VI and Title VII, some of the hot topics that we've seen very recently, in November, early November, there was a Dear Colleague letter from the Office for Civil Rights reminding schools of their obligation under Title VI to address discrimination and harassment and provide all students a school environment free from discrimination based on race, color, or national origin. There have also been numerous recent OCR resolution agreements addressing harassment and discrimination based on ancestry, and with respect to EEOC guidance and Title VII, EEOC guidance has expanded the protected characteristic of sex under Title VII to include sexual orientation and gender identity. And with that, I'm going to turn it over to Ellen to talk about Title IX.
Hi, everybody. I hope that you all can hear me. I want to talk a little bit, like Mackenzie said, about Title IX and the Pregnant Workers Fairness Act. I know a lot of you are involved in your organization's Title IX compliance, and I will say that we could do, and we do, all-day trainings on Title IX. So this is going to be, as Christine mentioned, an overview of Title IX. And obviously, if you have specific questions, let us know. But this is just to sort of familiarize you with the basic compliance requirements. So Title IX, another federal statute, states that no person in the United States shall, on the basis of sex, be excluded from participation in or be denied the benefits of or subjected to discrimination under any education program or activity receiving federal financial assistance. Obviously, the vast majority of institutions of higher education receive federal financial assistance and are thus subject to Title IX. Some schools have some religious exemptions. We will not be covering those today. That's a little too in the weeds for us. So it's easy for everything covered by Title IX that's not Title IX sexual harassment to fall off of our radars. And so we need to remember that Title IX is a broad statute of which sexual harassment is a part. It covers a variety of things. But sexual harassment is not all of it. It's a significant piece of Title IX compliance because the response to sexual harassment is so regimented. So Title IX covers recruitment, admissions, and counseling, financial assistance. It also, so those are areas obviously where you can't discriminate. It also covers gender equity in athletics. It covers sex-based harassment, which includes sexual assault and other forms of sexual violence. It covers pregnancy and parenting. It covers treatment of our LGBTQI+ students. It is applicable to discipline, single-sex education, and employment. So as you all know, there is overlap then with Title VII. So I mentioned the broad coverage. We need to think about, when we think about Title IX compliance, we also need to think about how to manage our Title IX operations. So part of that is remembering that Title IX covers more than just sexual harassment. Again, equity in athletics, pregnancy and parenting. You need to think about your organizational structure. You need to think about whether your organizational structure is conducive to compliance. You need to think about following proper procedures and routing reports appropriately. You need to think about training your personnel, and you need to think about conflicts of interest and bias. So those are all areas where we see our clients getting hung up a little bit, and so they're good to think about on the front end. So some of the compliance requirements for Title IX, you need to designate a Title IX coordinator. That is a job that, a position that needs to be filled at all times. You cannot have gaps. So if you have one Title IX coordinator, you need to be thinking to yourself about what would happen if that person were to step down or for some reason was unavailable. You need to publish your non-discrimination statement, as is true for many of the other statutes that we're discussing. You need to adopt, publish, and follow a grievance process to address Title IX sexual harassment. You need to provide the required training. So any of your employees who are involved in Title IX compliance need training regarding the scope of Title IX, the definition of sexual harassment, the scope of education programs and activities, how to conduct the grievance process, and how to serve impartially without stereotyping. You also need to document your processes and keep appropriate records of your processes for the appropriate length of time. So those are some of the basic Title IX compliance requirements. So, like I said, Title IX is very broad and it covers a variety of things, but the one that I think we focus on very much for obvious reasons is sexual harassment under Title IX. So, what sexual harassment does Title IX apply to? Title IX applies to sexual harassment in the education program or activity of a federal funding recipient. That is essentially everything that the institution does. It's very difficult to find something that a college or university does that is not considered a part of the education program or activity. So as consistent with that, Title IX defines education program or activity to include all of the operations of the institution. Title IX, however, does not apply to private conduct occurring in a private location that is not part of an education program or activity. And one thing you need to think about is how you will address those types of issues if you are presented with them on your campus. If you determine that something is not a part of your education program or activity but might have implications for your school. So what is sexual harassment? Sexual harassment is conduct on the basis of sex that falls into one of the following 5 categories. The first category is quid pro quo harassment, which is when an employee of the university conditions the provision of an aid, benefit, or service on an individual's participation in unwelcome sexual conduct. Then we've got hostile environment harassment, which is unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive, has to be all of those things, that it effectively denies a person access to the university's education programs or activities. This is, I would say, the area where we get the most questions. So it's a definition that you should really get very familiar with, and you should think about how your policy addresses it, defines it, responds to it. Sexual assault includes rape, sodomy, sexual assault with an object, fondling, incest, or statutory rape. Relationship violence includes dating violence and domestic violence, which are not the same thing. They're two different things. And then stalking is a course of conduct directed at a specific person that would cause a reasonable person to fear for their safety or the safety of others, or suffer substantial emotional distress. So if you are presented with sexual harassment under Title IX, what do you need to do? Well, your college or university should have processes in place to respond, and those processes must include an investigation, a live hearing, and an appeal. Now, when I say it has to include an appeal, the person doesn't have to appeal, but you need to have processes in place for if someone does appeal. It's important to note that the same person can't be the investigator or a decision maker. That's important because at many of our smaller institutions, there are, you might only have one Title IX coordinator, one investigator. So you need to be thinking about the depth of your bench, as it were, for Title IX compliance. You need to be thinking about what happens if a particular investigator, when you only have one, is not available. What happens if you need an appeal decision maker and you need someone different from whoever made your decision at the hearing? So you need to be thinking about staffing, and you need to be thinking about training for all of those things. There's also, not on this chart, but a possibility that you have in the context of Title IX is an informal resolution. Both parties or all the parties affected and the Title IX coordinator need to agree to engage in that process, and it's not permitted if the respondent is a non-student employee accused of committing sexual harassment against a student. So that's something to keep in mind. It's a process, part of the grievance process, but doesn't go through the hearing and the appeal necessarily. So we've got a scenario here. A student files a formal complaint with the Title IX coordinator saying that she was sexually assaulted by another student while they were on a university-sponsored study abroad trip in Paris. How should the university respond? Should the university initiate the Title IX grievance process because they received a formal complaint? Should the university dismiss the formal complaint? Should the university dismiss the formal complaint and determine if another university policy may apply? Or, as Mackenzie said, one of my favorite answers, I don't know. So I'm going to give you all a few minutes to think about this and respond. I've included this question because this is a little bit of a pet peeve of mine. I won't reveal what the pet peeve is until we get to the answer. So I'm going to count down 5, 4, 3, 2, 1. Thank you for all the people who are responding. So initiate the formal grievance process, got 51. Dismiss the formal complaint and determine if another university policy may apply is 44%. So we're sort of split between those two, a little less. I believe that the correct answer is dismiss the formal complaint and determine if another university policy would apply. I say that because the fact I can see how someone would say this should be pursued under Title IX because it was part of the university's programming. the reason I would say it shouldn't go through the Title IX process is that Title IX doesn't cover behavior that occurs outside of the United States. I'm glad no one said dismiss the formal complaint. I mean, well, alone, because you don't want to ignore bad behavior that affects your students. But at the same time, the university or college needs to think about whether, even though it can't go through the Title IX process, whether it needs to go through another university process that may be applicable. And that's going to be dependent upon your university or college policy. If you have another policy that applies to sexual misconduct that occurs outside of the context of Title IX. So we need to talk about proper procedures. So remember what Title IX covers and route it appropriately. So if your Title IX office gets a claim of discrimination based on race, for instance, it's not appropriate for the Title IX coordinator to just ignore that. The Title IX coordinator is to route that to the appropriate office. Educate your Title IX team members. So if you've got any folks who could be involved in the compliance process, so that would include, investigators, decision makers, appeal decision makers, anyone, make sure that they know your processes and they know what Title IX is all about. Use your formal grievance processes for allegations of sexual harassment as defined by Title IX, including sexual assault. Keep in mind that informal resolution may be an option. Post your training materials for your Title IX team members. This is a requirement, so you need to be sure to make your training materials public. And then you need to be sure that you've retained your records. I should also say that your formal grievance process, your written formal grievance process, should be made available to the public as well. I'm going to switch gears and I'm going to talk about now the Pregnant Workers Fairness Act. This is not a terribly complicated statute from what we can tell so far. It's quite new, but I did want to bring it up because it is new and we want people to know. We want people to know about it. So there are pregnancy protections in Title IX and the ADA and also in Title VII. The Pregnant Workers Fairness Act is a relatively new law that became effective in June of this year, and it applies only to accommodations. It's designed to sort of fill in the cracks for other statutes that protect pregnant individuals. It doesn't replace federal or state laws that are more protective. So if you're in a state where there are additional protections for pregnant workers, you should follow your state law. The Pregnant Workers Fairness Act is a base that you should be operating. You should be providing that level of protections or higher. There were proposed regulations issued, and the comment period has now closed. So we don't have the final regulations yet, but when we do, we will certainly keep you all updated. So the statute covers employees and applicants of covered employees who have known limitations related to pregnancy, childbirth, or related medical conditions. Covered employers include public and private employers with at least 15 employees, among others like Congress, federal agencies, employment agencies, and labor organizations. So the coverage is the same as for Title VII and under the ADA. You need to provide reasonable accommodations. And a reasonable accommodation is one that does not create an undue hardship for the employer or potential employer. So you need to provide accommodations to help apply for a job, perform a job, enjoy equal benefits and privileges of employment, and temporarily suspend the performance of an essential function of a position if certain conditions are met. So the big takeaway for the Pregnant Workers Fairness Act is that it understands that even workers with uncomplicated pregnancies might need accommodations, and it requires employers to provide them. So that's a difference with the ADA or Title VII even. So if you've got a pregnant worker, the person doesn't need to be on bed rest, for example, to be getting accommodations. Just the fact of being pregnant might allow them to get accommodations. So some examples of accommodations that were provided by the House Committee on Education and Labor included allowing pregnant employees to sit or drink water, with closer parking, flexible hours, appropriately sized work clothing, additional break times if necessary, leave or time off to recover, and they can be excused from strenuous and or unsafe activities. Again, these accommodations are only required if someone, if they do not create an undue hardship for the employer. Covered employers can't require an employee to accept an accommodation. They cannot deny a job or other employment opportunity based on the need for an accommodation. They can't require pregnant workers to take a leave if another reasonable accommodation could be provided. I feel like it should go without saying that employers can't retaliate for seeking accommodations, and you can't interfere with an individual's right under the Pregnant Workers Fairness Act. Now I'm going to turn it over to Christine to talk a little bit about disability laws.
Thanks, Ellen. Today, we're going to talk about 3 federal laws that prohibit disability discrimination: the Americans with Disabilities Act, Section 504 of the Rehabilitation Act of 1973, and the Fair Housing Act. Please keep in mind that many states also have laws that prohibit disability discrimination. Many of them are modeled on federal law, so generally your compliance obligations will be the same, but I think this is a good reminder for all of the discrimination laws that we're talking about. There will be state versions of civil rights laws that apply to sex discrimination and race discrimination and other forms of prohibited discrimination. So let's start with Section 504 and the ADA. Section 504 prohibits discrimination based on disability in any program or activity that is operated by a recipient of federal funds. The ADA actually has several different titles within it. The Title I under the ADA applies to employment. Title II of the ADA applies to public universities and colleges. And Title III applies to private universities and colleges. So Section 504, it does not matter if your institution is public or private. It only matters if you are a recipient of federal funds. If so, you fall within the coverage of the Act. The ADA, as you can see here, different sections of the law apply depending on whether you are a public or private institution or with respect to employment. Title III of the ADA does not apply to religious organizations or entities that are controlled by religious organizations. Keep in mind that what organizations fall within that exemption is not always clear-cut. And because we're giving you just a high-level overview today, we're not going to be getting into an analysis of the relevant court decisions that relate to the religious exemption. Keep in mind also that Section 504 does not have an explicit comparable exemption, nor do many state laws. So religiously affiliated institutions should not leave this seminar thinking that they don't have any compliance obligations in this area, because you probably do, because of the applicability of Section 504 and applicable state laws. The Fair Housing Act prohibits discrimination in housing based on race, color, religion, sex, national origin, familial status, and disability. The Act also includes physical accessibility requirements for facilities. So this law tends to get the most attention on campuses related to the use of assistance animals. Assistance animals includes emotional support animals. Be aware that there are some requirements with respect to facility accessibility. So in terms of the physical construction, entrances, etc., of your housing facilities. Those requirements are not as detailed as the accessibility design guidelines under the ADA, but they shouldn't be ignored when you're thinking about the physical accessibility of your spaces. So like some of the other laws, the scope of covered activities under these laws is quite broad. They cover your programs, benefits, and services. So this can be admissions and recruitment of students. It's going to be academics, whether those are academic requirements or how information is conveyed within the learning environment. It may be financial aid. It can be housing. It can be housing with respect to, again, the physical space that people are in. It can be housing with respect to housing requirements. It can be food within housing in terms of people who have dietary restrictions. It can be athletics, extracurricular activities, transportation. And then it can also be communications and facilities, which are maybe open to the public and have a broader range of people using those. So one of the things when we think about the disability laws, one of the key concepts which comes up frequently is the obligation to accommodate individuals. And many of you, I'm sure, have heard of the phrase reasonable accommodation. So what are the obligations under these laws? Well, under Section 504, you must make modifications to academic requirements that are necessary to ensure that such requirements do not discriminate against a qualified student with a disability. Under the ADA, we must make reasonable modifications in policies, practices, or procedures when necessary to avoid discrimination based on disability. And under the Fair Housing Act, we must provide reasonable accommodations to afford persons with disabilities an equal opportunity to use and enjoy a dwelling. So if we think in a practical way, what might accommodations include? They could be sign language interpreters. They could be note takers or scribes, perhaps a permission to record a lecture. Frequently, there are test-taking accommodations, such as giving exams in alternate formats, extending a time allowed, providing a quiet room for test-taking. They might be the removal of architectural barriers. They might be giving someone a single room in campus housing as opposed to requiring them to live in a double. They may also be dietary adjustments. So there's a wide range of what those accommodations can look like, and they can come up in a variety of contexts. So we've got a poll here. Again, you can just click on the slide. And the question is, if a student provides your institution a note from a physician, do federal disability laws require that you approve whatever accommodation the student has requested? Your choices are yes, no, or I don't know. We'll give you a few seconds to put your answers in there. I'll give you a couple more. Make sure we've got at least half of you responding before we show the results. Okay, so let's see what you all think about this. Okay, so the majority of you has said no, you don't have to approve whatever accommodation the student has requested. And that is absolutely the correct answer. So there are some limitations on the obligation to accommodate. Institutions are not required to provide accommodations that would fundamentally alter a program, that would conflict with the essential function of a job, that would pose an undue burden. Schools do not need to provide the student's preferred accommodation, so long as an alternative accommodation is effective. And schools do not need to provide personal devices, such as wheelchairs, hearing aids, or personal services, such as assistance with eating or dressing. So again, it's important to remember that accommodations should not lower the academic standards or compromise the integrity of an academic program. Those would not be deemed reasonable. A school can maintain its academic, conduct, and technical standards. And when we think about what poses an undue burden, and we're thinking about cost, for example, keep in mind that these are institutional obligations. So even if an accommodation is expensive and an individual academic or employment unit might have trouble with their budget paying for it, whether the accommodation poses an undue financial burden will be reviewed at the institutional level. So it's very difficult to meet that exception and say that an accommodation poses an undue burden for most routine accommodation requests. So areas that disability questions or issues tend to arise and pose particular challenges are listed here. And each of these areas is, of course, very complex. We don't have time today to delve into each one. Our goal today is that you recognize that these different areas could implicate disability laws, and you may need to look at them more closely or consult with your counsel or your internal experts on these topics. So we've talked a little bit about academic and work accommodations and what some of those might look like. There, of course, can be housing accommodations. A very common one is a request for a single room. It might also be requests for things like a portable air conditioning unit or something along those lines. Animals on campus is something which poses challenges, whether those are emotional assistance animals, whether those are service animals in training, whether those are service animals, and how to navigate those issues all implicate federal disability laws. We also see this come up with respect to threatening and self-harming students, facility accessibility, and digital accessibility, all very complicated topics. As you're issue spotting, these are all things that you want to have in the back of your mind that there may be disability laws implicated. So what are your compliance requirements? Under Title II of the ADA, which again applies to public institutions, you must designate a responsible employee to coordinate your compliance efforts. And you must publish the coordinator's name, office address, and telephone number. So much like your Title IX coordinator, you have to have an ADA coordinator under Title II if you're a public institution. You must also adopt and publish grievance procedures for providing the prompt and equitable resolution of disability discrimination or harassment complaints. Keep in mind that this complaint procedure doesn't have to be a standalone procedure. We often recommend that schools use their non-discrimination policy complaint resolution procedures for this purpose. If you do, it should be explicitly stated in your procedures so that it's clear that this is what is serving as your disability grievance procedure. Under Section 504, you also have some compliance obligations. This first one, you must designate at least one person to coordinate your compliance efforts. So this covers both public and private. You have to have a Section 504 coordinator. And again, you must adopt grievance procedures that incorporate appropriate due process standards and provide for the prompt and equitable resolution of complaints alleging disability discrimination or harassment. Again, the complaint procedure does not need to be standalone. We often recommend schools use their non-discrimination policy and procedures to accomplish that. Per recent OCR enforcement actions, these procedures must apply to complaints from students, employees, or third parties. Okay, switching gears, we're going to move into a brief overview of some age discrimination laws. And we're going to start with the Age Discrimination Act. This prohibits discrimination based on age in programs or activities that receive federal financial assistance. The law does not cover employment discrimination. That's the ADEA, which Ellen's going to talk about in just a moment. So this law may present itself for you if you have rules that limit access to programs or services based on age. For example, the law would not permit you to exclude individuals above a certain age from your on-campus housing. So you could not have a rule, for example, saying if you're over the age of 24, you can't live in your on-campus housing. There are a few exceptions in the law, which we don't have time to delve into today, but just be cautious about making any age-based rules. And if you want to do so, look more carefully at this issue, knowing that this law exists. There are some compliance obligations under the Age Discrimination Act. You must designate at least one employee to coordinate your compliance efforts. And in your notice of non-discrimination, you must make sure you're including age as something you don't discriminate on, and you must identify your coordinator by name or title, address, and telephone number. I would say this is one of the more commonly overlooked compliance requirements. Many people are not aware that there's an Age Discrimination Act apart from the employment law, and they are not aware that you need to name a coordinator. So we hope that you leave today knowing that you need to do that. And again, you need to adopt and publish some grievance procedures for the prompt and equitable resolution of complaints. Again, those can be wrapped into your general non-discrimination complaint procedures. Just be clear that that's what that is. Okay, I am now going to turn it over to Ellen to discuss the ADEA.
Thanks, Christine. I do think it is important to point out that the ADEA, as Christine said, is different from the ADA. The Age Discrimination in Employment Act covers the employment context. It's unlawful for an employer to refuse to hire or discharge someone or discriminate in any way based on the individual's age. The same is true for it's illegal to limit, segregate, or classify employments in a way that would deprive the individual of employment opportunities or otherwise adversely affect the employee's status because of the individual's age. So, to whom does this apply? The law applies to employers with 20 or more employees, including state and local governments. So that would include most colleges and universities, both public and private. It protects individuals 40 years of age or older. I can assure you that that seems younger every single day, but that is the cutoff that has been determined. And it includes the protections apply to apprenticeship programs, job notices and advertisements, pre-employment inquiries, and benefits. So, for example, a school couldn't say, we have an apprenticeship program or an internship program for our undergraduate students that's limited to students of a certain age, under 40, anything like that. That would not be allowed under the Age Discrimination and Employment Act. An employee may waive the employee's ADEA rights. That usually presents itself in the context of a separation agreement. However, the waiver of ADEA rights cannot be assumed. There are certain steps that need to be taken. For example, the waiver must be in writing. It must specifically reference ADEA claims. So a language that says, I release all claims, we would recommend being specific and specifically referencing ADEA claims. It doesn't waive future claims. It must be in exchange for valuable consideration. The individual must have the opportunity to consult with an attorney, and the documentation must tell the individual about that right prior to any waiver. And the employee needs to have 21 days to consider the agreement prior to signing, and at least 7 days to revoke it after signing. So it's clear from this language that Congress didn't intend for these ADEA rights to be waived easily. And so it's something to keep in mind if you are having a separation agreement with one of your employers, either under happy circumstances or unhappy circumstances, that you need to be thinking about this language if a waiver is anticipated or would be helpful. So now I'm going to go over some practice pointers that generally apply to all of the compliance with the discrimination laws that we have been talking about. So it's really important that you publish your notice of non-discrimination on a public-facing website, and that it includes all the required information. It's also important that you adopt formal grievance procedures to address complaints of prohibited discrimination and harassment. So as Christine mentioned, we don't think that it's necessary that for every law that requires compliance, you have to have a separate policy. But it's a good idea to have an anti-discrimination policy that covers many of the types of discrimination that we've described. And generally, we recommend having it separate from your Title IX procedures. Your Title IX procedures are going to be very prescribed, and in the other areas, it's less regimented. The process can be somewhat less regimented than in the Title IX context. But anyway, you need to have policies to address all of these types of or procedures to address all these types of discrimination. But it can be one policy to serve as sort of an umbrella separate from your Title IX policy. Some schools are going to prefer to have more policies than just two. That's fine. You want to be careful to balance meeting all your compliance obligations and not overburdening yourself with procedures and differing procedures. So we recommend that all of our clients review their policies to ensure consistent and fair treatment of students and employees, regardless of personal characteristics. Review your policies to ensure no unintended adverse impact on particular groups, and provide training to the campus community about non-discrimination policies, where to report, and the complaint resolution procedures. Keep in mind that when we talk about training, there are different categories of training. There's training for the people who are coordinating and working in the process, and then there is training for the greater community. Obviously, you need both, but they are going to differ from one another. When at your institution you respond to incidents of discrimination, we recommend taking corrective action when you are on notice of discrimination or harassment. We've seen many times that schools will get in trouble because they were aware of allegations and no action was ever taken. That is not something that you want to happen. You want to be sure that you're assessing all of the allegations that come in and taking action as appropriate. And action I don't mean when I say that discipline necessarily. I mean, go through your process to determine if there's been a violation, and then if so, take the next step for discipline. We recommend obviously conducting prompt, thorough, and impartial inquiries designed to reliably determine what actually occurred, and assure that your responses are reasonable, timely, and effective. If you're hung up on time, if time is presenting an issue, make sure that you've documented the reasons why and that you've told the parties involved the reasons why. That's a good way to make sure it doesn't look like you're dropping the ball, as it were. Taking no action, not responding appropriately is an area where we see colleges and universities getting into trouble. With regard to your process, implement policies and procedures in accordance with the appropriate level of due process before reaching a finding or imposing discipline. The more significant the punishment, generally speaking, the higher the due process requirements are. So keep that in mind when you're thinking about your policies and procedures and how to respond. Assure that your decision makers and others involved are trained on the process and their role. This is really important. One of the reasons that we see colleges and universities drop the ball sometimes is when they don't have the appropriate training in place, and so their employees don't know what to do. For example, if an employee gets a complaint that falls outside of that employee's sphere of expertise, and this we talk about colleges and universities often being very siloed. The best way to avoid this is training and communication to make sure that your different university units are talking to one another so that things don't slip through the cracks. Also be vigilant for signs of bias in the process or by decision makers. When we think about bias or conflict of interest, one of the best ways to address that is through good training. This also goes back to the idea of wanting a deep bench. If someone is conflicted out of a process, you need to have someone else able to step in to do the work that's necessary to be done. And remediation. If discrimination or harassment is found, take reasonable, timely, and effective corrective action designed to stop the harassment, eliminate the hostile environment, and remedy the effects of the harassment on the individual who was harassed. And then take steps to prevent the harassment from occurring, including disciplining the harasser where appropriate. Again, training is essential here too, training for your community so that people understand what is prohibited, what your policies say, and how the process will work. So it looks like we've got about 4 minutes to talk about some questions that have appeared in the chat. So because I've been talking to you all and not looking at the chat, I'm going to turn it over to my colleagues to see if they have questions they want to start out with.
Sure, we have a number of questions and we'll try to get through as many as we can. I'm just going to kind of go through them in the order that we're seeing them here. Someone asked, with respect to emotional support animals as opposed to service animals, are there requirements to accommodate emotional support animals outside of the Fair Housing Act? The very quick answer to this is yes. If you get a request to use an emotional support animal from a student or someone else outside of the housing context, your obligation is to assess that under your normal accommodation process. So like any other request for an accommodation, you would assess the request to use an emotional support animal through that process, requiring documentation, etc. So you can't say no out of hand. You should follow your normal process to assess that request. We also received several questions about how the federal disability laws apply to threatening and self-harming students. So that very frequently comes up in the context of requiring students to undergo a mandatory assessment, particularly if they are struggling with mental health issues, and where schools have an involuntary withdrawal policy for students who may have mental health issues or are encountering some difficulties. So we don't have time to get into how the law applies in that context. If you want to, if your school is looking at requiring a student to be assessed or to do an involuntary withdrawal, that is an area rife with risk, and you would want to make sure you look at that very closely, whether you confer with counsel, whether you explore that internally with your experts. That is an area that the law would absolutely apply, and you would want to exercise extreme caution in that area because you don't want to be perceived to be discriminating against students who have mental health conditions.
It looks like we got some questions about Title IX and behavior that takes place outside of an education program or activity, for example, on spring break. I'm assuming the question about spring break is not a school-sponsored spring break trip, because I think if it's a school-sponsored spring break trip, you could consider that an education program or activity, and in which case your regular Title IX process would apply. If it's two students from the same school who've gone on spring break together, we need to think that to me, I mean, I think if it was two students who didn't go to school together and they just met up over spring break and something bad happened, I'm not sure how it would come up at your school, but if it came up and the respondent was a student at your school, I don't think, and Christine, pop in if you think that I'm wrong. I think there's an argument can be made that that is not a part of your school's education program and activity, and you could look to see if you have your non-Title IX university anti-discrimination policy would apply, but it's going to be difficult if you don't have a claimant at the school. If it's two students who do go to the same school and something happened over spring break and it was completely unrelated to any student education program or activity, again, my recommendation would be that you would follow your anti-discrimination policy if it were having an impact on the students once they were back at school. Christine, what do you think?
I think that I agree with you, Ellen.
Okay. All right. And then we had some questions. I hope that I answered it while I was speaking, but someone said that someone asked a question about why do we have the Pregnant Workers Fairness Act? It's because I think the purpose behind it is to make sure that people with normal pregnancies are able to obtain accommodations without saying, for example, that they have a disability. So that was my understanding of why the Pregnant Workers Fairness Act was added, like I said, to fill in the cracks. Oh my goodness, it's 2:01. I'm sorry. Okay, to be respectful of everyone's time, we will try to answer your questions offline. We will reach out to you in response to these questions. We want to thank you for joining us today. We hope the information was helpful to you and your organization. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with the recording of the webcast for watching and sharing. Be sure to complete our short survey. We do use your feedback to plan future programs that are applicable to your business needs. This concludes our webinar. Thank you so much for attending.